Wayfarer Studios, which is the studio that was co-founded and co-owned by Justin Baldoni and Steve Sarowitz, has responded in New York State court to the New York Times anti-SLAPP suit against them. The New York Times was named in Justin Baldoni and Wayfarer's countersuit against Blake Lively and others, but they've been dismissed from that case since the judge made the initial ruling in June. So the Times is now asking that Wayfarer pay their legal fees, costs, and disbursements. We went over the Times complaint back in September when this first came out, and I was going to go over Wayfarer's response in a live stream, but then I realized the answer is actually very short. It's like 6 pages, and there's not a whole lot of substance to it. It's just denying or admitting things paragraph by paragraph, like we saw in their answers to Blake Lively's lawsuit. So we'll take a quick look at it right now. We'll have a few other things to go over tomorrow. The judge today in Florida ruled against Popcorn Planet in his motion to quash Blake Lively's subpoena. Whether or not he decides to appeal is something for Andy to decide and to speak on. But as of right now, the judge says that Andy doesn't qualify for journalistic privilege. He is an independent YouTuber. He's not a salaried employee for a news organization. And I don't know the exact standards off the top of my head, but it sounds like that is something that can be appealed. There's also Blake's responses to the motion for judgment on the pleadings and the motion for summary judgment that's due tomorrow night. So I'm probably going to have a busy day tomorrow, which is why I'm going to keep this one short. So just to review a couple of things in the Times complaint here that they're responding to, the Times is seeking to recover costs, fees, and expenses incurred in the defense of a defamation action brought by Wayfarer and parties associated with Wayfarer. And then they cite the Lively versus Wayfarer Studios case. Strategic lawsuits against public participation, SLAPP suits, are lawsuits used to inhibit the exercise of free speech and harass publishers by forcing them to expend time and resources on baseless litigation. Under New York's anti-SLAPP law, defendants in lawsuits involving public petition and participation may now file an action to recover damages, including costs and attorney's fees, from any person who commenced or continued such an action without a substantial basis in fact and law. So we don't actually have anything that says this was commenced or continued without substantial basis in fact and law. So I don't know about that, but they go on to say the anti-SLAPP law also provides for compensatory and punitive damages against plaintiffs who, like Wayfarer, commence or continue meritless legal claims for the purpose of harassing, intimidating, punishing, or otherwise maliciously inhibiting the free exercise of speech. Now, where have I heard that before? I think it was dozens of content creators who were hit with subpoenas to intimidate them out of talking. Now, granted, it was Blake Lively, not the New York Times, who did that, but I don't have any sympathy for the New York Times because they intentionally left out a lot of the story that they were telling, didn't give the other side a fair chance to answer the allegations, and did no real due diligence, in my opinion, before trying to hand Blake Lively some kind of Me Too crown. That's not a knock at the Me Too movement. That's a knock at Blake Lively and the New York Times. I believe they failed the Me Too movement. But yes, people do use the legal system like this to intimidate or harass people, not only through lawsuits, as we've seen, also through subpoenas. And unfortunately, that's happening to Andy from Popcorn Planet right now. Andy's a friend of mine. I went to his house and filmed for the documentary, and I'm a public person, so people already know who I am. I don't have to be afraid of that, but there were crew members who have the right to speak to somebody, speak their mind, who are afraid of Blake Lively and Ryan Reynolds for good reason. And this isn't fair to them, and Andy should be afforded the journalistic privileges that the judge is trying to deny him. But that is a topic for another video. I'm sorry. Anyways, let's get into Wayfarer's response a little bit here. Like I said, there's not a whole lot of meat to it. I mean, there's just not much here. A lot of it says this consists of legal conclusions that require no response. So, that's a lot of the paragraphs are saying the same thing. In paragraph 14 here, it says that Wayfarer denies the allegations, except admits the action was filed on January 16th, and the action was consolidated with Lively's lawsuit, and that the Times was not originally named as a party to the action. And I think people forget that they were initially trying to sue the New York Times, I believe, in California, but I don't think the New York Times was ever actually served with that complaint. And then they ended up being brought into the New York lawsuit. For a lot of these, they're going to refer the court to the amended complaint. Number 22 is going to be one of the main points here. Wayfarer denies the allegations and respectfully refers the court to the opinion, which speaks for itself. Now, the opinion is the judgment. And we're going back to the Times here really quick. So number 22, what they're talking about says, it's clear from the district court's opinion that the claims against the Times lacked any basis in fact or law. So what a lot of people will say when they only read headlines from like TMZ or other news sites is that the judge found that the Wayfarer party's lawsuit didn't have any merit, or that nothing that he said was true. And that's not the case. The issue was that because Lively had filed the CRD complaint and given it to the New York Times, what they were reporting on was basically something that was put forth an illegal complaint. So they have a privilege for that. They have the journalistic privilege to report on that, and they can't be sued for it. That does not mean that they acted responsibly, in my opinion. I obviously don't think that at all, but they were protected by that privilege. Just like people are protected by the things that they say in their legal documents. So if somebody files a complaint or files some sort of court document and makes an accusation against somebody or says something about somebody that's not necessarily true, I mean, they're protected by that. They have that privilege. So I can't go and like sue somebody for defamation if they say, well, actually, you know what? This kind of happened a little bit. Somebody in a court in California wrote this whole thing that I was like a crazy psycho cult leader and a criminal. But he wrote that in a legal proceeding, knowing that I can't sue him for defamation if it ever came to that, because it was put forth in a legal brief. Or not a brief, but a legal document. It was part of the court process. So I believe people abuse this sometimes. I think that they intentionally use the courts to do this because they know that it protects them from facing the consequences of the very untrue things they're saying. So number 27, Wayfarers, denying knowledge, information, sufficient form of belief, blah, 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 except denies that the amended complaint lacked a basis in law and fact. And number 27 from the Times complaint was saying the Times incurred not less than $150,000 in legal fees and costs for defending against the lawsuit, which had no basis in law or fact. And then in paragraph 32, Wayfarer denies the allegations. Further, they deny compensatory damages are recoverable because the action was not commenced or continued for the sole purpose of harassing, intimidating, punishing, or otherwise maliciously inhibiting the free exercise of speech, petition, or association rights. Plaintiff's cause of action is barred in whole or in parts because Wayfarer's amended complaint was not a SLAPP. As far as the affirmative defenses, though, I'm going to be honest, there's a lot here I don't understand. So I'm going to have to wait and ask Omar or somebody else who can help me out with that because I don't want to, give you wrong information. But I can go through them for you. So second says the complaint fails to state a cause of action. Third, the action is barred by the doctrine of waiver. Fourth, by the doctrine of estoppel. Fifth, by the doctrine of unjust enrichment. Sixth, by the doctrine of unclean hands. Seventh, plaintiff's cause of action is barred for failure to satisfy a condition precedent to commencement of this action. Eighth, plaintiff's cause of action is barred by its failure to mitigate its damages. Ninth, plaintiff's cause of action is barred in whole or in part by the First Amendment of the United States Constitution. 10th, if plaintiff sustained any damages as alleged in the complaint, such damages are attributable in whole or in part to conduct on the part of plaintiff, its agents, or its employees. And 11th, plaintiff has not incurred damages as a result of any actions, inactions, or conduct by Wayfarer. So they're asking that this complaint be dismissed with prejudice, that Wayfarer is granted its costs and expenses incurred, and whatever further relief the court deems just and proper. So that's all there is to it right now. Like I said, there's not too much for me to go through tonight, so I just wanted to get through that really quickly because tomorrow's going to be a busy day. So I'll catch you guys again soon. Bye.